If you've been charged with a criminal offense, you will often be released with certain conditions, most commonly known as bail. Often, proposed bail conditions are accepted by an accused person simply so that they can be released from custody. Once out of custody, it becomes evident that certain conditions may be too restrictive or cause significant issues with family or employment. The good news is that bail conditions can be changed in accordance with Section 523, Sub 2 of the Criminal Code. The easiest and most cost-effective way to vary bail conditions is by consent of the Crown Prosecutor. This means that the Crown Prosecutor agrees to changes in the bail conditions. The changes are then presented to a judge who generally will simply sign off on the variation. A consent bail variation can happen very quickly without the need to conduct a costly bail hearing. If seeking the consent of the Crown Prosecutor to vary the bail conditions, it's important for an accused to provide as much supporting documentation to justify the request. Common examples would be a travel itinerary, or proof of change of address, or proof of change of employment. Now, if the Crown Prosecutor refuses to consent to the bail variation, an application must be brought before a justice in the Court of King's Bench. This is a much more onerous and time-consuming process that requires an actual hearing in which the judge will make the final decision. This process is called a bail review application. In it, the accused bears the onus under Section 520 of the Criminal Code to show cause on a balance of probabilities why the current order should be vacated and new conditions put in place. This can be established by showing an error in principle in the order or a material change in circumstance that would make it unjust not to change the original order. Now, there are only 3 circumstances in which an accused person can bring a bail review application. 1, there's been an error of law. 2, where the original decision was clearly inappropriate, such as giving excessive weight to one factor or insufficient weight to another. And 3, where there's been a material change in circumstances. Now, when considering the material change in circumstances, the reviewing judge is to consider any fresh evidence in a flexible manner to consider if the new evidence for review should be considered. Now, such considerations are due diligence, relevance, credibility, and the effect on the result. Now, if you lose on the bail review, you do have the opportunity to take it in very narrow circumstances to the Court of Appeal. You have to show there's a reasonable prospect of success, that the court applying the law could possibly conclude that the application for release should have been allowed. This is where bail has been denied. These are the only ways that you can go to the Court of Appeal if you've been denied on a bail review. Now, if you or someone you know is seeking to have your bail conditions reviewed, contact me today for a free, no obligation consultation.